The grandeur of the Supreme Court chamber had seen countless legal minds rise and fall, but this morning held a peculiar charge in the air. Pam Bondi, representing a coalition of states challenging a federal regulatory overreach, stepped before the bench with quiet determination. The case had been written off by many as an uphill battle. The federal government had precedent, institutional weight, and the support of much of the legal commentariat. Bondi, a state attorney with little prior experience before the nation's highest court, was widely expected to be outmatched. Justice Amy Coney Barrett, known for her incisive questioning and strict constitutional interpretation, wasted no time. Her tone was sharp, almost dismissive, as she opened with a barrage of hypotheticals intended to unravel Bondi's reasoning. The courtroom, filled with legal clerks, journalists, and scholars, braced for what seemed like the beginning of a dismantling. But Bondi stood firm. She responded not with defensiveness, but with clarity and precision. Her voice steady, she referenced foundational federalism cases, threading together a nuanced argument about the limits of congressional authority under the Commerce Clause. As Barrett pressed harder, questioning, interrupting, circling back, Bondi's poise only deepened. Her responses began drawing nods from unexpected corners of the room. A constitutional scholar seated in the second row leaned forward. The atmosphere shifted. Barrett, who had initially seemed poised to dominate, began to slow. Her follow-up questions turned more probing than dismissive, more exploratory than adversarial. Bondi cited Prince versus United States and NFIB versus Sebelius, weaving together a vision of state sovereignty that challenged prevailing assumptions about federal supremacy. She wasn't just defending her clients. She was building a new framework. By the end of the first hour, the tension had given way to a strange sense of awe. The Solicitor General, due to argue next, flipped through his notes with increasing agitation. In private corners of the chamber, law professors whispered with disbelief. What had been assumed to be a routine defeat for the states was rapidly becoming a landmark constitutional moment. Barrett leaned back, arms crossed, studying Bondi with an expression no longer of skepticism, but contemplation. For the first time during the argument, she requested further elaboration, not to challenge, but to understand. Bondi launched into an extended constitutional analysis, articulating a three-part test to evaluate federal regulations impacting state functions. The courtroom fell silent. As Bondi returned to her seat, the gallery buzzed with hushed astonishment. Barrett reviewed her notes, visibly reassessing her earlier stance. The Solicitor General, now pale and tight-lipped, was seen making last-minute revisions. Within hours, legal blogs erupted. SCOTUS blog published an unprecedented mid-session article, Bondi's Tour de Force Reshapes Federalism Debate. Constitutional law professors across ideological lines praised her argument. A prominent liberal scholar tweeted, "Regardless of where you stand, Bondi's command of precedent today was extraordinary." Bondi declined interviews, releasing only a statement acknowledging the gravity of the case. Barrett remained silent until a speech weeks later where she remarked, "Legal brilliance can emerge from unexpected places." Behind closed doors, the Supreme Court's internal dynamics shifted. Barrett reportedly told her colleagues, "We witnessed something rare today. Bondi's federalism framework deserves serious consideration." A decision once thought certain now hung in genuine uncertainty. Inside the hushed chambers of the Supreme Court, a tremor had passed through the marble halls. What had begun as a routine argument had turned into a constitutional showdown that none of the justices had foreseen. Bondi's voice, clear and unwavering, still echoed in their ears. Even the stenographers had paused, as if aware they were transcribing a moment that would find its way into legal history books. The Solicitor General rose with a visible unease. Normally poised and assured, he now shuffled his notes, adjusting to a reality where the state's argument, led by someone the legal establishment had largely dismissed, had not only held ground but seized momentum. His planned attacks on Bondi's reasoning had to be recalibrated. Her synthesis of federalism doctrine, supported by precise citations and historical nuance, had narrowed the space he had to maneuver. He began his argument, but the mood in the chamber had shifted. Justices leaned forward, brows furrowed, now hyper-aware of the depth of Bondi's framework. Questions that might have once been used to reinforce the government's position now turned probing, even skeptical. Justice Kavanaugh asked whether the Solicitor General could distinguish his position from the Bondi framework. Sotomayor, from the other ideological flank, wondered aloud whether Bondi's model might better preserve the balance intended by the framers. Bondi remained silent, composed, listening intently as her opponent struggled to neutralize the conceptual clarity she had laid out. This wasn't just a performance. It was a seismic challenge to established assumptions about who could speak authoritatively on constitutional matters. Barrett notably asked fewer questions than usual. She seemed to be observing, internalizing, her pen moving only to underline points that now required further thought. After the arguments concluded, the justices returned to their private conference. The air was electric with unspoken acknowledgement. Barrett broke the silence. "We owe this court a duty, not just to decide, but to understand, and I fear we underestimated what we were presented today." Justice Gorsuch nodded. It was uncommonly persuasive. Outside, legal media erupted. Social media feeds buzzed with clips from the oral argument, many highlighting the once tense but now respectful exchanges between Barrett and Bondi. The Atlantic published a special editorial titled "When the Court Listens," praising the rare judicial humility on display. The New York Times ran a Sunday feature. "From Florida to the federal bench, how Pam Bondi rewrote the rules of federalism." Bondi refused interviews. Her only public comment was a written statement. "It is the advocate's role to present the best argument. It is the court's role to listen with discipline and judge with integrity." Law schools raced to revise their syllabi. The term Bondi test began to circulate among academia. Professor Dana Rodriguez at Columbia tweeted, "Teaching this next semester, not just the argument, but the example, preparedness meets principle." Even critics of the state's position begrudgingly acknowledged the excellence of her argumentation. That evening, Barrett attended a previously scheduled private reception at the American Law Institute. She declined to comment on the case, but made an unscripted remark that rang with wider meaning. "The measure of justice isn't certainty, it's the willingness to reconsider." In the weeks that followed, internal drafts of the court's opinion circulated. Justice Gorsuch took the lead on the majority. Barrett requested a separate concurrence, not to dissent, but to reckon. She penned a striking paragraph that acknowledged how Bondi's arguments had prompted her to revisit assumptions she had held for years. The leak of Barrett's draft concurrence, unofficial but widely reported, only fueled public fascination. "This is judicial integrity," wrote a columnist in the Wall Street Journal. "Not just deciding, but learning." Meanwhile, Bondi was invited to speak at Yale, Harvard, Stanford, each offering her positions as visiting lecturer or senior fellow. She accepted none, choosing instead to return to Tallahassee. When asked why, she said only, "I have more work to do." 3 months later, the Supreme Court issued its opinion. The states had prevailed, 6-3. Gorsuch's majority opinion adopted the very structure Bondi had proposed. A 3-part test to determine when federal regulatory power intrudes upon traditional state functions. Legal analysts confirmed what everyone suspected. This was more than a legal win. It was doctrinal transformation. Justice Barrett's concurrence drew particular attention. In it, she quoted her own previous opinions, then dissected them through the lens Bondi had provided. Where I once saw coherence in a strict reading, she wrote, I now recognize the risk of rigidity. Bondi's framework preserves federal integrity without erasing state sovereignty. It was an extraordinary moment, a justice publicly grappling with her own legacy, influenced not by a colleague, but by an advocate. The media reframed the story, now calling it the Bondi Barrett Doctrine. CNN aired a special documentary. The Federalist Society hosted an exclusive panel where both Bondi and Barrett appeared, not to debate, but to reflect. The room was packed with young law students, their notebooks open, their expressions reverent. Barrett said little during the event, but when she did speak, her words echoed with sincerity. We must always be open to persuasion. The Constitution demands nothing less. Bondi responded with a calm conviction. Every good argument begins with respect for the law, for the forum, and for the people on the other side. We're not here to win. We're here to clarify what justice requires. Law professors began to teach their students about pulling a Bondi, a phrase that entered legal slang to mean rising beyond expectation, redefining the terms of debate, and forcing even the highest powers to reconsider. The Supreme Court's archives now list the case under its formal citation, but among legal circles it's known differently. Not Florida v. Federal Government, but Bondi versus Assumptions. And in the marbled corridors of 1 First Street, etched not into stone but into memory, lingered the voice of an advocate who didn't just argue the law, she changed it.